convene again today to arrive at a decision. So we are in court basically to hear the decision that the judges will arrive at following the arguments they heard from both sides yesterday. And usually when the day sitting is over, we know that the first respondent does not make itself available for those press conferences. The petitioner and the second respondent's spokespersons, who usually speak to the media right after every day's sitting. And yesterday, both parties, and I'm talking about the petitioner and the second respondents, were very optimistic. They were upbeat that today's decision will go their way based on the arguments advanced by their lead counsels. It remains to be seen what impressions the judges make out of those arguments. Again, just to give you a background as to why we are here, for those who perhaps haven't been following this petition, on the 9th of December 2020, the chairperson of the EC made a declaration that may announce the president, Nana Addo Dankwa Akufo-Addo, as president-elect. Then, by the 10th of that same month, December, the EC had come with some press releases making some certain corrections to portions of the declaration. But effectively, the announcement was that the declaration, those corrections did not effectively affect the... of course, I have Mr. Gabriel Asare Dako. We'll call him Gabi. He's here. So I need 2 minutes of your time. And sorry. Mr. Gabi, so you are a lawyer, an interested party in this matter as well. Yesterday, we just want to break down the issues for the understanding of our viewers. So yesterday in court, the petitioner sought to seek the court's permission to reopen his case. You were opposed to that. Why?
Well, I think the reasons were pretty simple, in the sense that you brought the electoral commissioner and the winner of the elections to court. You've opened your case. You've called your witnesses. Even the petitioner himself didn't think it was necessary for himself to be in the box. He called witnesses, and the witnesses themselves, when you ask them questions about a petition and they don't like it, they can turn around and say, I'm not a petitioner. You said you were going to call 5, and eventually you ended up calling 3. And you closed your case. And right from the beginning, I think on the 20th of January, the respondents filed a motion, which is that it was a preliminary objection asking the court to dismiss the case summarily. What it meant was that they felt that there was no cause of action. So that should have given counsel for the petitioner a hint that right from the beginning, these guys don't think that you have a case. So it's difficult for you to rely on the fact that they could open their case and you have an opportunity to cross-examine them. That should have given him a hint. Right. And it didn't come on just because the court said that they will deal with that matter at the end of the trial. The preliminary objection, which was raised by the respondents, the court did not act on it, said that they will give their ruling on it at the end of the case. But that should have told you that really they don't think you have any cause of action for them to respond to. So they were not likely to exercise that right to elect to adduce evidence. So that really is the thing. And then when you tell us that you were relying on it, on an affidavit, what they said in an affidavit to an interlocutory application on your part, that when the opportunity comes, you can put these questions to them at cross-examination. I find it difficult because if you believe them, if you relied on it, then why did you file even a review? Well, I mean, of course.
But currently where we are at, it does appear the petitioner is seeking to use other routes to arrive at the same destination, the destination of cross-examining the chairperson of the EC. Now, the route is that the chairperson of the EC as an individual is not a party to this case and therefore can be subpoenaed to court.
Well, when you look at the Constitution, when it tells you about the Electoral Commission, it tells you that Electoral Commission is comprised of what? The chairperson, 2 deputies, and I think 4 other commissioners. Okay? So essentially, even when you go into case law will tell you that you cannot, when you sue a corporate body, it is a person who is responsible for that corporate body that will come to court. So there's no way that we could have brought the whole Electoral Commission to court. It is the chairperson who represents, and that has been the practice. So I think trying to make that pedantic, sedentary of an argument that it is the person, but why is the person necessary? The person is necessary to you because she's the chairperson. She's the returning officer of the Electoral Commission. That's the only reason why she matters in this case. So you cannot try to then say that is the person that you want, because the person who is representing the Electoral Commission. So, well, let's wait and see.
Thank you very much. We hope to talk to you.
Your questions during the press conferences, excellent.
Thank you very much, and I hope to see you after that to ask you some of those questions as well, sir. That was Gabriel Asari-Ochudako, a member of the MPP. Is one of the very interested. That's Professor Jenana Opoku-Agyeman, the running mate to the petitioner, Mr. John Dramani Mahama, in the 2020 elections. She has been in court from day one. You would recall that she happens to be the first female vice-chancellor of any university in the country. She was the vice-chancellor of the University of Cape Coast until she was appointed as Minister of Education under the administration of former President John Dramani Mahama, and she stepped up to become his running mate in the 2020 elections, the elections which currently is in controversy, which declaration is in controversy here at the Supreme Court so far. We are getting indications that the chairperson of the EC will soon arrive, Mrs. Jane Mensah, whose declaration of the results on the 9th of December is in contention right now. And most specifically, the controversy appears to be around her and not around the second respondent's witness as well, because indeed it's not only the first respondent, in this case the EC, who has indicated that it will not present a witness. The second respondents have also indicated so. It does appear that the petitioners are very much interested in getting the first respondent's witness, in this case Mrs. Jane Mensah, to be cross-examined, and not particularly so much interested in cross-examining Mr. McMenu. But it's also instructive to remind you that yesterday in court, the lead counsel for the petitioner did indicate to the court that he wanted a certain tape to be played, a tape in which Mr. McMenu, who is the witness for the second respondent in this case, was heard talking about some vote pardon, but of course the chairperson of the EC, Mrs. Jane Mensah, has arrived and going through some security procedures. Of course, she's here with her deputy commissioners. From day one, she's always been in court. She's here right now with her deputies. Of course, you see Dr. Bosman Asari is one of her deputies. Dr. Bosman Asari, once upon a time, was a lecturer at the Political Science Department of the University of Ghana until he was appointed one of the deputies of the EC when Madame Charlotte Osei's regime came to an end. You recall that there were some petitions against the Charlotte Osei-led EC, which led to the dissolution of that administration, upon which Mrs. Jane Mensah was appointed together with her other deputies ahead of elections 2020. Of course, before then they had also supervised district level elections. And you recall that there was also the issue of a referendum when Ghana had to vote as to whether or not we needed to create more regions. It was under the regime of Mrs. Jane Mensah and her deputies. But of course, we are in court today because the petitioner, Mr. John Dramani Mahama, is appealing to the court to nullify the results that were declared on the 9th of December, because according to him, none of the two leading candidates, in this case the petitioner himself and Mr. Nana Addo Dankwa Akufo-Addo, none of them attained the mandatory, constitutionally required 50% plus mark, more than 50% mark. None of them, according to the petitioner, attained this feat, this number that would indicate that you genuinely won an election, and that's what they have been trying to prove in court. And the case was filed on the 30th of December, given the constitutionally mandated time limit within which election petitions can be filed. But of course, there have been some significant changes since the last time there was an election petition in Ghana. In fact, the very first time in the history of the Fourth Republic that there was an election petition was in 2012, when Nana Addo Dankwa Akufo-Addo, Dr. Mahmoud Bawumia, as well as the late Jacob Ichebi Lamte, who were the petitioners at the time, came to court to seek the court to reverse the results that were declared after the 2012 elections, and declare Nana Addo Dankwa Akufo-Addo as winner of that election. Of course, we all know what happened. For 8 months, we were here at the Supreme Court for the panel to determine whether or not there was merit in the petition brought before it in 2013 for the 2012 elections. Of course, there have been very significant changes here. You realize that in this case the petitioner is just one, and that's because since 2012 different constitutional instruments have been introduced and nullifying, so to speak, some of the earlier constitutional instruments. We are currently operating under CI 99, which specifically speaks to election petitions and how they should be organized, and all the other issues around election petitions in the country. One of those is the fact that it is just one person who can petition, unlike in 2012 when we had 3 petitioners. That's number one. Then number two, you'll recall that in 2013, when the 2012 election petition was being heard, the petitioners actually sued, called 2 respondents, in this case the EC and Mr. John Dramani Mahama, in 2012. But the NDC then said they were an interested party in this suit because the candidate John Dramani Mahama had become candidate on the ticket of the NDC, and therefore, if the NDC at the time was the John Dramani Mahama was being sued at the time, then it was only sorry, so I'll come to that point later, but I've just been joined by one of the lead spokespersons for the petitioners' lawyers, Mr. Tambaklo Eduji. Thank you very much, sir. So we realized that you applied to the court to be allowed to reopen your case. We are in court today, but for those of our listeners who still are confused as to what this is all about, what you are hoping to do, for the layperson out there, it's like you did not prepare adequately before coming. Now you've come to court, you've heard arguments from the respondents, you want to go back and now prepare to come and face them. Is that the case?
Absolutely no. That cannot be the case. The truth of the matter is that at the time we were closing our case, the Electoral Commission chairperson had put before the court a witness statement and has served us a copy. The second respondent had, through his witness, Peter McMahon, filed a witness statement and has served us. So as at the time we were closing our case, one, the chairperson had deposed to an affidavit when we came for a review in respect of the interrogatories. The affidavit in opposition was deposed to by the chairperson, whereupon she indicated that she will be taking the stand. And that when we get to that point, the 12 questions that we're asking, we could put it through her. If you recall, one of the justices actually asked Mr. Chikata that is it his case that those questions cannot be asked during cross-examination. Yes. So at all times we were prepared, except to say that we were taken when after we said we have closed our case, only for the lawyers for the first and second respondent to now say that even the witness statement that they have filed, they do not intend to rely on it.
So you had not been able to prove your case at the time you were closing your case?
No, we have.
If you had, then why the insistence to have the first respondent's witness?
I think that there's a certain misconception that as at the time you are closing your case, it should be the case that, oh, you had finished. Remember that our allegation is that the returning officer of the 2020 presidential election misreturned the election. She misreturned the election to the extent that, one, there were issues of vote padding. That has not been denied. Two, as we speak, there is one CI 135, which is the presidential declaration instrument, which has been gazetted. Under cross-examination, the second respondent lawyer actually said, quote, manifestly erroneous, the declaration on the 9th. If something is manifestly erroneous, what does it mean? Has there been any other declaration save the 9th one? So these are the issues.
Okay, so we know about a declaration on the 9th, but subsequently we also saw and read and indeed published press statements from the EC indicating corrections of certain minor errors, so to speak.
No. Has there been any other gazette? Has there been any other instrument? Unless, of course, you are telling me that you can use a press release to amend a constitutional instrument. It's never done. It's never done. So these are the issues.
All right, so we often do not want to preempt what the court will say, but we know that a decision will be taken today, and we hope to speak to you right after the decision. And that was Mr. Tamaklo Eduji, one of the spokespersons for the legal team of the petitioner. And it's just about time. We'll be going over to the courtroom soon. Mr. Abraham Amaliba is one of the legal team members of the petitioner. He's also just arrived in court, and when you see people arriving in droves around this time in court, then it indicates that even the judges are ready, and probably in the next few minutes will be making their presence in the courtroom for us to hear their ruling. So basically, today, unless something else comes up, we basically expect that the ruling, the decision that the court has arrived at, will be read to the public, to the petitioners' lawyers, as well as the respondents and their lawyers as well. And after that, the court will then indicate what steps to take next. It's instructive to remind you that earlier, late last week, the court did indicate that all parties should present their written addresses by close of day on Wednesday, 17th of February, which is just tomorrow, so the court could reconvene on the 18th Now that the petitioner has made an application, and now that the application has been heard, which was tomorrow, and now that we are expecting a ruling, it remains unclear what then becomes of the written addresses. Indeed, yesterday in court, Mr. Akoto Ampao did indicate that they would proceed. The respondents, at least the second respondent, would proceed to present its written address. However, he presented a concern also. That the concern was that the petitioners must not be allowed to see their address, no matter what the circumstances are. The court assured them that that would exactly be guaranteed. But so then it remains to be seen what then becomes of the written statements if the wishes of the petitioner are granted today. But if the wishes of the petitioner are also not granted today, what are the steps that the court will then take next? Those are issues that remain unclear for now. As soon as we grab any of that information, surely we will make it available to you. Now, earlier we're trying to bring you an analysis and a comparison of 2012 petition and the petition of 2020 and some of the differences. We arrived at that point where I was telling you about the fact that in 2012 Okay, so I'm getting indications that the courtroom is almost ready and we have to move in there so that the ruling can be heard. But of course, we'll go to the studio now where Morris and George Sapo have been engaging other persons, experts out there to further break down the issues. Then we'll return to court and hear the ruling. After that, we'll by all means be back here to break it all down for you.
All right, thank you very much, Abdul Hai Mumin. And whilst we wait for the justices to take their seats, we'll go for a quick commercial break. We'll be right back. Stay with us.
When you need a shoulder to cry, run on my pumping, so we pray was suicide.
2020 election petition hearing. We're still here in studio. Earlier on, our colleague Abdul Hai Moment spoke to some spokespersons, both for the respondent and the petitioners. So he spoke to Gabi Ochidako and Edujit Tamaklo, who is a spokesperson for the petitioners. We still have on the line Dr. Ajiman Budu, who has been helping us understand this particular case in simple terms. We are live on Ghana Television and on GBC News. You're also live on Unique FM and on Facebook at Ghana Broadcasting Corporation. Doc, are you there?
Yes, I'm here, Morris.
All right, so there was this issue of you can subpoena a person and not a party. Can you help us understand this and how that relates in this particular case?
All right, before we get to that point, I'm getting information, or there's information to the effect that a letter was written by counsel for the petitioner to the address to the Chief Justice of the Republic of Ghana, setting out a number of things that they wanted the Honorable Chief Justice to consider before today's ruling. And so I believe that that's why there's a bit of a delay before the court actually sits. I'm hearing that the court will sit in about 30 minutes time or so, and this information was it's out there on other media platforms.
Sure.
That there was a letter to the effect that had to do with the proceedings yesterday, that one of the justices talked about the fact that, or asked the question whether the ruling of the court on the objections earlier on in relation to the closing of the case of the respondents, whether that was not a bar,
a judicial bar,
the petitioner trying to reopen their case to subpoena the electoral commissioner. And I believe that the letter basically suggests that counsel for the petitioner wants to be heard on those arguments, or wants to argue those points before the court considers its ruling. I mean, this information is coming from sources within the precinct of the Supreme Court, other media personnel who are there. And I believe that's probably what's causing this delay. And so I just felt that we need to put it out there so that people are aware of what is actually happening.
Sure.
And
but is it a practice that you can apply to be heard on some of the comments that the justices make? Is that a practice?
The practice that what? I didn't quite get the question.
I mean, what they are seeking to do, specifically to address what, I mean, the comments that one of the justices made, is that a practice? Are they allowed to do so?
I mean, throughout the proceedings of the court, or throughout proceedings in this particular petition, or the hearing of this particular petition, we've seen that whenever there's an application before the court, counsel who is moving that particular motion or has brought that particular application is allowed to argue his point out, or move the motion and then make his arguments in support of that particular application. And then the respondents are also given an opportunity to respond to those specific arguments. And sometimes counsel for the petitioner is given leave once again to respond to the response that have been given by the respondents. And then once all is done and once he rests, then the court will decide maybe to ask further questions or to adjourn to consider their ruling and then give their ruling back. So that's usually the process that ensues before the courts generally. And I mean, this not being a motion before the court is simply a letter. That's the information that we're getting. That's if the information is true. That it is a letter addressed to the Chief Justice of the Supreme Court of Ghana, the Chief Justice of Ghana, basically suggesting that they wanted to argue some points or something of that sort. That is not necessarily how the procedure is, like I've explained, and we've all been witness to in these proceedings, that once the arguments come to a close, that is it, and the court will deliver its ruling. But of course, The Supreme Court is the Supreme Court. It is the highest court in Ghana, and they can, depending on the exigencies of the circumstances, they can take decisions and do take decisions that, in their opinion, are just in terms of the case or matter. Because remember, at the end of the day, the main reason why the court is sitting and hearing the petition is to deliver justice. And so when they believe that the justice of the case so demands, they may make certain orders or give certain directions that they deem fit to properly dispose of the matter.
All right, so now you want to answer my question.
Yes, and your question had to do with subpoenas, and what was the first part of the question again?
So you can only subpoena a person and not a party in a civil case. So counsel for the petitioner, in response to the response that had been given by the respondents, both the first and second respondents, essentially suggested or was suggesting that the Electoral Commission, or the first respondents, had chosen not to adduce evidence, and the first respondent, being the Electoral Commission itself, choosing not to adduce evidence has no bearing whatsoever on the compellability of the chairperson of the Electoral Commission. So he tries to draw a distinction between the first respondent, which is the Electoral Commission, and the chairperson of the Electoral Commission, which is Mrs. Jean Adukwe Mensah. So that was a distinction that he was trying to draw, especially in response to a statement, I believe, that was in the affidavit in opposition to their application to reopen their case, where essentially the deponent was suggesting that because the first respondent had been essentially been affirmed in their decision not to testify or not to adduce any evidence, she was also barred from essentially adducing evidence. And I'm just trying to summarize what that particular paragraph stated, not that those were the specific words. But we also know that the Electoral Commission chairperson throughout these proceedings has been announced as the one representing the first respondent, that is the Electoral Commission. Sure. And I believe that was one of the things that the court went into. And if you remember, the Honorable Chief Justice read a portion of their earlier ruling which talked about the fact that the party, which was the Electoral Commission, could not be compelled to adduce any evidence, meaning they could not be compelled to call witnesses to testify on their behalf, regardless of the fact that they had filed a witness statement, which was the witness statement of the chairperson of the Electoral Commission, Mrs. Jean Adukwe Mensah. So basically what the petitioner was saying in his arguments before the court yesterday was that there was a fundamental distinction between the Electoral Commission as an entity and the Electoral Commission's chairperson in the person of Mrs. Jean Adukwe Mensah. So to the extent, even though that the Electoral Commission cannot be compelled to adduce evidence, for instance, the court cannot compel the Electoral Commission to by all means call Mrs. Jean Mensah to provide testimony. The petitioner was essentially suggesting that if they were given leave to open or reopen their case, could cause a subpoena to be issued to compel the chairperson of the Electoral Commissioner, who is quite distinct from the Electoral Commission, to actually testify before court. Right. That was the distinction that was being made. Did you say she's quite distinct from the Electoral Commission? So we want
I'm just summarizing the argument that was being made by the petitioner.
Right.
That so the chairperson, as a matter of fact, the Electoral Commissioner is not necessarily the Electoral Commission. If you look at the Constitution, Article 43(1), it talks about the fact that there shall be an Electoral Commission which shall consist of A, a chairman, B, two deputy chairmen, and C, 4 other members. So the Electoral Commission, the commission itself, is comprised of not just the Electoral Commissioner, but 2 deputy chairmen, and as well as 4 other members, making 7 members of the Electoral Commission.
So in this case, there's a distinction between the person of Jane Adukwe Mensah and the Electoral Commission.
That is the argument that the petitioner sought to make. But a counter-argument, which I believe was made to some extent, was that, and even by reading the affidavit in the position, for instance, of the first respondent, seems to suggest that, and it's clear that right from the beginning, you know, when the parties are called, we see that the petitioner is called, and maybe Mr. Johnson Asiedu Ketia is representing the petitioner. First respondent is called, and Mrs. Jean Adukwe Mensah is the one representing the Electoral Commission. Then the second respondent is called, and Mr. Peter McMenu is the one representing the second respondent. So at all material times, Mrs. Jean Mensah, who is the chairperson of the Electoral Commission, has been representing the Electoral Commission in these proceedings. And of course, the Electoral Commission, it being the first respondent, you cannot necessarily bring the commission as an entity. The commission is represented by individuals, being a corporate entity or being a body corporate. So that is why the chairperson is representing the Electoral Commission. So to that extent, or to the extent that the chairperson of the Electoral Commission is representing the Electoral Commission, then it seems as though their interests align one way or the other. That is a sort of counter-argument to the point that they are distinct, because you can see clearly that the Electoral Commission chairperson is a member of the Electoral Commission. But obviously, these are arguments that are before the court or have been made to the court, and we believe that the Supreme Court will give its ruling on the issue and bring the matter to an end.
Right. So the petitioners have given indication that they will subpoena her to appear as an adverse witness. Is there any difference in cross-examining an adverse witness from cross-examining a witness who voluntarily mounts the box? Does she have any immunity? Can she appear and say, I don't want to speak or something?
So an adverse witness, and I believe we talked a little bit about this yesterday, but we weren't able to complete. An adverse witness can either be an unfavorable witness or a hostile witness, as it was referred to at common law. An unfavorable witness is simply a witness that may tell the truth or will tell the truth, but may not necessarily inure to the benefit of the party that calls that witness. A hostile witness, on the other hand, is a witness who may be hostile, for want of a better word, a witness who may not necessarily comply with what you seek to do, or may decide not to answer or be obstructive and things to that effect. And we know, for instance, that in Ghana, we refer to such witnesses as adverse witnesses, because if you look at Section 72 of the Evidence Act, NRCD 323, it talks about the fact that the court can exercise its discretion in a civil matter, either on its own motion or on the application of a party, to call a witness whose interest may be adverse to the party calling that particular witness. And so it is possible that you would have an adverse witness. And when you have an adverse witness, one of the things, and that goes to the question that you are asking, that what's the difference between, say, cross-examine an adverse witness to a regular or normal witness. So, for instance, you will be able to, you need to obviously seek the leave of the court to be able to treat that witness as an adverse witness. So you may ask leading questions. And leading questions are simply questions which preempt the answer, or questions that you already know what the answer to, or preempt the answer by virtue of the question itself. Another consequence of treating a witness as an adverse one is that the credibility of the witness or any part of his or her testimony may be attacked. So you can seek to impeach the character of that witness, because essentially once an adverse witness is called, there's no examination in chief, for instance. Once the adverse witness is called, straight away, the party calling that witness and seeking leave or having been granted leave to treat that witness as an adverse witness will be engaging in cross-examination. And so that is where, usually there would have been the examination in chief or the witness statement of that person would have been adopted. But for an adverse witness, we go straight into cross-examination at that particular point in relation to that adverse witness.
Right. Doc, the adverse witness, can he or she also have a lawyer, or in this case, the first respondent can also represent the adverse witness?
So what the rules or the laws provide, that once an adverse witness or a witness is called and that witness is treated or leave has been granted to treat that witness as an adverse witness, the other parties are also entitled to re-examination. And we know that re-examination usually takes place after cross-examination, which gives an opportunity usually or normally for the party that has called that witness to be able to also clarify certain statements or seek to close any holes that may have been opened during cross-examination in the testimony of that witness. So what will happen is that once the adverse witness is cross-examined by the party that has called that witness, the other parties in the case will also have the opportunity to also ask questions of that adverse witness by way of re-examination. So it will be treated as though it was re-examination of those parties. The court may also ask questions of the adverse witness as well.
So at the point where the adverse witness mounts the dock, in this case, she will cease to be the witness of the respondent, right?
The respondents in this case have no witnesses. We know already that they filed witness statements or they filed a witness statement but chose not to call that person to give testimony and closed their case. So they have at this point no witnesses in this case. So, and I don't want to preempt anything that's going to happen, so I'll stay away from specifics. Assuming in a civil case that a plaintiff has closed their case, the defendant has also closed their case, and the plaintiff seeks the leave of the court to reopen their case, for instance, to recall a witness, because that's one of the things that can be done. You may recall a witness. The court even is given power to recall witnesses if it deems it fit and right, or the justice of the case so demands. They can recall a witness to examine that witness again if there's some pertinent information or clarification that the court seeks. The same way, a party may also seek to, for instance, reopen their case to recall a witness. And I gave a specific example the other time, which is premised on Order 38, Rule 3E5 of CI 87, the High Court Civil Procedure Amendment Rules, CI 87. And what that order provides is that it is possible that a party may have filed a witness statement in a case, but then choose not to call that witness to adduce evidence before the court. In that situation, any other party to the suit before the court may also then seek to introduce that witness statement of that party, even though the witness statement is not yet in evidence and as a result can not be relied on as evidence. The rule provides that the other party may introduce that witness statement as hearsay evidence. Right. And they may do so, for instance, by recalling one of their witnesses so as to tender that witness statement to that particular witness. It's a possibility that can happen. So in a civil case of such nature, where a plaintiff seeks to reopen their case, they may do that. They may reopen their case for the specific purpose of, say, tendering in that witness statement, or may reopen their case to also seek the leave of the court to, for instance, compel some person to come and testify. And obviously, these are all discretionary matters that the court decides on the basis of the merits of the application before it.
All right. All right, Doc, we'll go for a quick break. Just stay with us. We'll be right back. We're going for a quick break, and we're still waiting for the justice to get back so as for the ruling. But before that, let's go for a quick break. We'll be back here. We'll be right back.
All right, so welcome back. We're still waiting for the justices to make their appearance at the Supreme Court, and we'll hand you over to the Supreme Court as and when we get indications that the justices have arrived. We hear there has been a short delay due to a letter that the petitioners have written to the Chief Justice to hear them on a particular case which has to do with one of the statements that one of the justices made. In effect, she was saying that the ruling that they made on the 10th of February upholding the decision of the respondents not to present a witness to as evidence, some way, somehow, presents a judicial bar to what the petitioners are seeking to do now. That is, trying to open their case and subpoena the Electoral Commissioner to appear in the witness box at all costs. We still have via Zoom Dr. Kweku Ajiman-Budu. He's a law lecturer. He's a lawyer first, a law lecturer, and head of Law Center's Gimpa Faculty of Law. Good to have you join us once again, Doc.
Yeah, yes, thank you.
All right, Doc, before we went for the break, we're talking about the adverse witness, and you said that the adverse witness will be re-examined by the other counsels or the respondents. Now, if the respondents don't have a witness, how are they going to re-examine? I mean, emphasis on the word re-examination, understanding what re-examination is also about.
No, so the point is that at the point where a plaintiff has, for instance, has applied to the court to seek leave to treat a witness as an adverse witness, at that particular point in time, that witness is examined as though the witness is being cross-examined. The witness is examined as though he or she is being cross-examined. And so once the party that calls the adverse witness, you know, under normal circumstances, you would call a witness who will be testifying to help establish your case. But it is possible sometimes that a witness that may help your case in some way may not necessarily want to testify or may be obstructive one way or the other. And that's why the law provides this idea that a witness may be treated as an adverse witness. So the interest of that witness may not necessarily be in line with yours. In actual fact, it may be adverse to your interest, you, the party calling that particular witness. So under those circumstances, the witness is not made to testify in chief or give his give his evidence, testimony, the evidence in chief, or even file any witness statements. That person is treated right from the onset when he or she is called as an adverse witness, if the court grants the leave for you to treat that person as an adverse witness. So once you are done with that cross-examination, because you called the party and the party was treated as an adverse witness, one whose interest was adverse to yours, your opponent or the party on the other side or the other parties in the suit will also be given an opportunity to re-examine that adverse witness. And so it's only just fair, it's part of the fairness of the court processes and procedures that when a party is cross-examined as an adverse witness, the other party is given an opportunity to re-examine that witness as well.
And this time around, the adverse witness, is the adverse witness allowed to have his or her own lawyer to represent her also in court?
It's not a question of having your lawyer represent you or not. It's as though it's similar to, for instance, when the court calls a court expert to an expert witness to give testimony in a trial, because there may be issues in play that are technical that requires an expert. So, for instance, if the issues that needs to be resolved has to do with structural engineering, for instance, or mechanical engineering, and the issues are that complicated, a court expert or an expert witness may be called by the courts to give testimony that will help the court arrive at a conclusion, a just conclusion. It is in the same vein that if a witness is treated as an adverse one, the other party has the opportunity to also examine that witness. And even before that point, it's even possible that you, the party calling a witness, and usually witnesses that you call have to or will usually be called to help you establish your case, to give testimony that will make the existence of the facts that you are alleging more probable than not in a civil case, which may lead to the reliefs that you're seeking being granted. It is possible that a witness you may call may turn out to be an unfavorable witness, because, for instance, the testimony of the witness that you feel he would give may be to support your case, but he may come there and be telling the truth all right, but may tell it in a way that is not necessarily in support of your case. And that is what is usually referred to as an unfavorable witness. So even though you called him yourself, he turns out to be unfavorable to your case. So these are things that happen or can happen during trials or during hearings, especially within the context of civil cases, but also it could happen in criminal cases as well.
All right, so it would be a gamble if you called an adverse witness. I mean, you will be gambling if you do that.
It's a gamble calling any witness at all, because like I'm saying, a witness, remember, we said before that the Evidence Act clearly provides that a witness needs to, the only way in which you can testify, generally speaking, is that you must have personal knowledge of the matters that you're testifying about.
All right.
So the witness is the only one that has, obviously there are exceptions because there's hearsay and all that, which is second-hand testimony, not necessarily first-hand. So you may call a witness that has first-hand knowledge of the matters to which he or she is testifying, but the testimony the witness gives may end up not supporting the claims that you are making. So it is a gamble one way or the other when you're calling witnesses, because at the end of the day, regardless of the facts that you are alleging and regardless of the reliefs that you are seeking, you need to be able to establish by evidence what you are seeking the court to agree with you on and to grant you your reliefs. And the testimony of the witness as well as the evidence provided by witnesses are key. And so it is possible that your witness may not necessarily help you establish your case. It's a gamble that you take because the court needs the truth to arrive at the conclusion. And it is the witnesses who have personal knowledge of the matters to which they testify that would be called. So if the person turns out to be unfavorable, and it happens sometimes that you know what the witness is going to say, but he comes to court and starts saying something totally different from what you thought that person was going to say. Then you realize that the witness is either an unfavorable witness or is an adverse witness, and you may seek the indulgence of the court to treat that person as an adverse witness.
All right. So the 10th of February ruling, which ruling upheld the respondent's motion not to adduce evidence. But before we do that, I've just realized that the lead counsels in this particular case have been the ones who have been doing all the talking from day one. This is just engaging my mind. Under which circumstance would, say, Chachu or Akoto Ampao, say today I'm not coming to court, and so let's say Tony Lita should take over?
I mean, it's possible. I mean, we are all humans, and it may be possible that, for instance, a lawyer in a case may not be feeling well, and so may ask his learned colleague or learned friend to hold brief for him in court. It's very possible that may happen, and so it's not something that is out of the ordinary or strange for that matter in court proceedings. It happens sometimes. There are numerous reasons why counsel may not be available And so sometimes you would inform the court, if there's enough time, you may inform the court ahead of time that you may not necessarily be available. For instance, it's possible that you may have 2 cases that have been scheduled around the same time, one in two different courts altogether. And since it's not possible for you to be at those 2 courts at the same time, you may ask a learned friend to hold brief for you, or you may seek to, and he may seek to have the case stood down for a bit so that other cases may be dealt with, and then subsequently, when you come, you may conduct your own case. Or if he is apprised of the case and, for instance, works with you in your chambers or works on that particular case and thus is authorized to deal with the case, he may decide, or it may be decided that he can continue with the case on your behalf at that particular point in time. So it's not, and you may be sick. It's possible that you're sick and you can't physically attend court, and so somebody needs to hold brief for you. So these are things that happen. These are ordinary and normal things that happen. Even in our workplaces, sometimes you may be sick and you will not go to work, or get sick leave, or take a day off and things of that sort. Lawyers are no different than any other person.
Okay, so let's talk about that ruling that I earlier referred to. My understanding was that at that particular point where the respondents said they were not going to allow their witness to mount the box, the Supreme Court, granted them that at that particular point and said we cannot compel the witness to mount the box. Does it bring conclusivity to the issue, and that even after that ruling, there is no point in time that maybe a circumstance may arrive where there will be the need for the respondents to allow their witness to mount the box?
So if I get your question right, you are basically trying to, or asking whether it is possible for a witness. I didn't quite hear the last part.
I'll just asking whether that particular ruling brought finality, and so after that ruling, there was no way that the EC chair could, mount the box.
To answer that question, we need to understand what that ruling was in relation to. The ruling had to do with an objection that had been raised by counsel for the petitioner in relation to the first respondent and then subsequently the second respondent choosing not to adduce evidence and therefore closing their case. The petitioner was objecting that they could not do that, and that by virtue of the fact that the first respondent in particular had caused the witness statement to be filed and served on the parties involved in the case, they had elected at that point to adduce evidence, and they could not renege on that election. So the ruling had to do with whether or not, indeed, by virtue of the filing of a witness statement, a party is compelled at all costs to call that witness to give testimony. And what the Supreme Court said in its ruling was that on the basis of Order 38, Rule 3E5 of CI 87, the High Court Civil Procedure Amendment Rules of 2014, it was possible that a party that had filed a witness statement may choose not to call that witness to testify. And we know that the witness statement is not evidence until you have called the party making the witness statement, sworn the oath, and the statement adopted as that person's evidence in chief. Until that point, the witness statement is simply a witness statement and it is not in evidence. And so Order 38 Rule 3E5 gives latitude to a party to decide that, yes, I have filed a witness statement, but no, I am not going to call the witness to give any testimony, for instance, because on the basis of the evidence I have heard so far, there's no case that has been made out in the first place for me to even waste my time to call any witness to adduce any evidence on my behalf, and that the court should decide the case on the basis of the evidence they have before it, which generally would have come from the plaintiff at that particular point in time. So that is the context of the ruling. It specifically had to do with whether you can compel a party to call a witness at all costs simply because they have filed a witness statement. And the court held that the law was settled that a party will not be compelled to enter the witness box and testify in support of his or her case, and that it was a risk that parties who decline to give evidence take, knowingly or knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. That is the ruling of the court, and that is the context within which the ruling was given, specifically to whether when a party has closed this case, it must be compelled or it can be compelled to call a witness to testify on that party's behalf,
right,
simply because they have filed a witness statement. The issue now before the court doesn't have to do necessarily with that, because the court has given its ruling on that. The issue before the court now is that the petitioner is seeking the leave of the court to reopen its case. And then they, the petitioner, on the basis of the motion that they filed, want to compel the EC chairperson to testify. So it doesn't have to do with the other party being compelled to produce a witness to testify. It has to do with the petitioner in this case, or a plaintiff in a civil case, requesting to reopen their case for them to be able to subpoena a witness to testify in the matter. I hope the distinction is clear.
Very clear.
And
very clear.
Isn't the same witness we are talking about here with the earlier ruling and with this subpoena that might or might not actually be heard? Isn't it the same witness we are talking about?
Basically, it's the same person.
Okay.
It's the same person that essentially was the subject matter of the initial ruling. But the fundamental distinction was that this person was supposed to be a witness for the first respondent. And the application or the objection by the petitioner was that the first respondent was stopped because of the election they had made, and that the first respondent must necessarily call the EC chairperson to testify. What is being argued here is not the same thing. What is being argued here is that the petitioner, upon closing their case and upon the fact that the Supreme Court has ruled that they cannot compel a party to adduce evidence by way of calling a witness, the petitioner now is seeking to reopen their case so that they, the petitioner, can then call that person by way of a subpoena to testify. That is the fundamental distinction between the two.
So it does not present a judicial bar, does it?
All right. Before we go into that one, let's go to the Supreme Court now. They are just about taking their seats. We'll be right back. Over to the Supreme Court.
Writ number J1/5/2021. John Dramani Mahama. This is Electoral Commission of Ghana. Nana Ado Dankwa Akufo-Addo. Please, who is representing the petitioner? Samuel Ofosu Ampofu, my lords, representing the petitioner. Lords, Jane Mensah, chairperson, is representing the first respondent. Mr. Peter Nunu is representing the second respondent, my lords.
If your lordships please, I appear for the petitioner and with me my learned friend Tony Litha.
May it please my lords, Justin Amenuvo appears for the first respondent. With me, Alexander Samoa.
If it pleases your lordships, Akoto Ampa for the second respondent. My lords, with me are my learned friends, Frank Davis and Kweku Esrifi.
My lords, at the end of the day,
Excuse me, sir.
I'm sorry.
Yes, excuse me. Please accept our apology for the delay in today's proceedings. We try as best as we can to be very, very punctual. We had the problems with the running out of the room, so thank you very much. Yes.
My lords, at the close, right at the close of yesterday, when I sought leave to respond to counsel for the respondent's submission, a question came from the bench in respect of whether, based on your ruling that you delivered on the 11th, whether the position that I was taking could hold. And I believe your lordship read a passage of your ruling at that point. My lords, we have respectfully sought your permission to have that matter fully argued, because it really came right at the end of the proceedings yesterday. And we believe that in the interest of justice, it will be appropriate that that important legal matter should be aired fully. And we have attached to our letter to your lordships, we have attached some of the authorities that we intend to rely upon in order to make clear that the position that we have taken, or that we are taking in respect of that point that was raised, is the legally accurate position. And we believe that it will be in the interest of justice that we all be given a chance to make arguments on the matter.
Counsel, with due respect, it's a legal point, and we've taken notice of it. Yes. So don't worry. It is a legal point which the authorities have been cited. You certainly look at it. This is the ruling of the court. When the petitioner in this case closed his case with the testimony of his third and last witness, Mr. Robert Joseph Meteruno, on the 8th of February 2021, the court, as our procedural rules and trials provide, called on the first respondent to open his defense by the calling of his witness, whose witness statement had already been filed on the orders of the court. This witness happened to be the chairperson of the first respondent, Mrs. Jane Adukwe Mensah. Counsel for the first respondent told the court that he had weighed or scrutinized the case of the petitioner as presented by his three witnesses, and in his view, the petitioner had not provided any substantial evidence in proof of his case, for which the first respondent had to mount the witness box to testify in answer. The first respondent therefore prayed the court to determine the petition on the oral testimonies and data presented by the petitioner through his witness and decide the main issue at stake, which is whether or not none of the 12 presidential candidates who contested the 7th December 2020 presidential elections did obtain more than 50% of the valid votes cast in the said elections. The second respondent, who was declared as winner of the elections by the first respondent, whose declaration ignited the filing of the instant petition, associated himself with the first respondent on his prayer and told the court he also did not desire to give in testimony through his attorney as contemplated. According to him, the petitioner did not discharge the burden imposed on him by law to produce sufficient evidence to buttress his case, so there was no need for him to say anything in explanation. He supported first respondent's prayer that the court should resolve the petition on petitioner's evidence, so he said the burden was on him to prove the reliefs he is seeking. This position of the respondents to close their case without adducing any evidence at all, which the law permits them to do, did not go down well with the petitioner. Counsel for the petitioner resisted this position of the respondents and prayed the court to compel the first respondent chairperson specifically to testify as first respondent witness, since he had filed a witness statement to that effect and therefore had elected to testify. As for the second respondent, petitioner said he was not bothered about his refusal to testify. The court adjourned for the parties to submit legal arguments for its determination of the matter, which they did. On the 11th of February 2021, the court dismissed the petitioner's objection to the respondent's decision not to testify and gave reasons in the written ruling delivered for that purpose. One of the reasons given by the court in dismissing the objection of the petitioner was that this court could not compel the first respondent to call its chairperson as its witness, as Rule 3E, Subgroup 5 of Order 38 of the High Court Civil Procedure, Rule CR 47 as amended by CR 87 permits them to do so. Immediately after the court's ruling on the issue, the petitioner filed the instant application. It was filed on the same 11 February 2021 and almost around the same time that this court delivered its ruling, dismissing petitioner's objection to the closure of respondent case. There is no doubt that the instant motion was triggered by the ruling of this court, in which the court endorsed the respondent's prayer not to volunteer any evidence whatsoever. The petitioner did not hide his feelings and expressed it lucidly under paragraph 15, 16, and 17 of his affidavit in support of the application as follows. Quote, 15. As a result of the ruling of the court of Thursday, 11 February 2021, it has become necessary, I am advised and very believe that my counsel use the subpoena powers of the court under Order 38 Rule 10 of CR 47 to compel the attendance of the chairperson of first respondent to appear and testify in court. 16. At the time my counsel closed my case, the representation that had been made by each respondent to the court, and specifically to me, was that witnesses who had filed witness statements were going to testify. It therefore came as a surprise that both counsel for respondents announced on Monday, 8 February 2021 that this was no longer the case. 17. My counsel is seeking leave of the court to reopen my case to enable the subpoena referred to above to be served on Mrs. Jane Adukwe-Mensah so she can appear before the court to testify. End of quote. The application is headed Motion on Notice for Leave to Reopen Case of Petitioner to enable Chairperson of Electoral Commission to testify. From all indications, the target of the petitioner in this application is not the second respondent, who has also filed a witness statement through an attorney, but the chairperson of the first respondent. The application, which is not known under our rules of procedure, has been brought under our inherent jurisdiction as contended by counsel for the petitioner. According to petitioner, he is praying the court to reopen his case, which this court had declared closed on his own instructions, to enable him subpoena the chairperson of the first respondent to testify as a hostile or adverse witness. The petitioner advanced almost the same argument he made before the court during his objection to the closure of the respondent case. The respondents have strongly opposed the application and have cited both local and foreign judicial decisions to support their arguments. Legal counsel for the petitioner urged on the court that he wanted the chairperson of first respondent to testify as an adverse witness of the petitioner. Counsel also made references to paragraphs 31, 32, and 33 of the affidavit in support of the application as to why he wanted the chairperson of the first respondent to testify. The other point petitioner's lawyer kept urging on the court was that the chairperson performs an important constitutional duty and must be made to account to the people for her stewardship and to vindicate herself. The question is, how can the chairperson of first respondent vindicate herself when he is not on trial before us? He was neither being personally sued nor arraigned before this court on any complaint or accusation, civil or criminal, for which he was to explain or account to anybody for anything he has done or not done. It is the institution, the Electoral Commission, which he has, that has been accused by petitioner of not having performed its constitutional duty according to law. Does the petitioner need the personal testimony of the chairperson of the institution sued before he could prove or establish the alleged non-performance of his constitutional duty by the first respondent? We do not think so. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary, 9th edition, edited by Brian A. Garner, defined a hostile witness as, quote, a witness who is biased against the examining party, who is unwilling to testify, and who is identified with an adverse party, also termed adverse witness, end of quote. A hostile or adverse witness, as the definition shows, as we understand the term in practice, is therefore a witness who has been called by a party to testify in support of his or her case and who, whilst in the witness box under examination in chief, performs hostile and gives evidence contrary to the party who called him and in support of the opponent's case. The party in such circumstances can apply to the court to treat such a witness who is already in the witness box as a hostile or adverse witness. This would enable the party calling him to cross-examine him as if he is a witness of his opponent to solicit the truth in respect of the issue at stake. A witness who has not yet entered the witness box to testify cannot therefore be called an adverse or hostile witness under any circumstances. The court exercises its inherent jurisdiction inter alia to correct errors in procedure and to ensure that no miscarriage of justice is occasioned during a trial. Inherent jurisdiction, which is also referred to as the inherent powers doctrine, is the principle that allows courts to deal with various matters over which they have intrinsic authority. The petitioner has not demonstrated to us in any way that the decision of the respondent not to testify, which was upheld by this court in its ruling of 11 February 2021, has occasioned him any miscarriage of justice. That decision is backed by law, particularly our rules of procedure, case law, and settled practice. We demonstrated this in our ruling of 11 February 2021 when we rejected petitioner's objection to the respondent's decision not to testify. At the time this application was filed, petitioner had expressly closed his case, likewise the respondents. He is therefore seeking our discretion to reopen his case and to lead further evidence, which evidence he never disclosed to the court. He is not entitled to his prayer as of right. It is subject to our discretion, and before we can exercise our discretion in his favor, we must satisfy certain basic conditions as laid down by case law. The general expectation imposed on all litigating parties is to place the whole of their case before the court at the time of the hearing. The process of invoking the inherent jurisdiction of the court at the close of the case of the party to reopen a closed case in order to adduce fresh or further evidence is thus an necessary step which the importance of finality of litigation fronts upon, save the presence of exceptional circumstances. In the Canadian case of Oakley versus Royal Bank of Canada, 2013 ONSC 145, 2013 OJ number 109, Supreme Court, Andrew J. held, quote, the court requires the parties to litigation to bring forward their whole case in both civil and criminal matters. The Crown or plaintiff must produce and enter in its own case all clearly relevant evidence it has. On the other hand, a trial judge has the discretion to permit a party to reopen its case. This discretion, however, must be exercised judicially. It must involve a scrupulous balancing of the accountability of counsel for decisions regarding the prosecution of his case and the interest of justice. End of quote. Though this Canadian case is not binding on us, it has a persuasive effect as it espouses the principles governing reopening of closed case for the purposes of adducing fresh or further evidence. Back at home, our own Benny JSC, then Benny J, gave a similar holding in the case of Combact vs. Lambian, 1989-91 Ghana Law Report, page 324, at page 326 as follows, quote, the general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen as improviso, which could not have been foreseen. Such witness could, in a civil case, only be called with the consent of all parties. And although the Evidence Decree 1975 NRCD 323 permitted the court to call or recall witnesses, it was subject to the general rule. End of quote. Though the above definition made reference to the calling or recall of a witness by the trial court, the same principle applies where it is any of the parties who applies for such a call or recall after the close of their cases. One of the leading cases on application to reopen cases is the Canadian case of 671122 Ontario Limited versus Sagas Industries Canada Incorporation, 2001 SCC 59 2 SCR 983 SCC, which was referred to as by counsel for second respondent. In that case, the court approved of a two-stage test, which was first articulated in Scott versus Cook, 1970 OJ number 14872OR769. That test, which is intended to assist the trial judge in exercising his or her discretion to reopen the trial, requires the applicant to show that the evidence he or she seeks to adduce is said that if it had been presented at trial, it would probably have changed the results. And two, prove that such evidence could not have been obtained by reasonable diligence before the trial. End of quote. This same test is what a party who intends to lead evidence or further evidence in the trial or on appeal must satisfy before a court could grant such a request. In the case of Poku versus Poku, 2007-2008 Supreme Court of Ghana Law Report 996 at page 998, which was cited by counsel for the second respondent, this court, per Wood CG, expressed the principle succinctly in the following words, quote, the rule is intended to assist an applicant who has made a genuine attempt to look for the evidence and has met with favor. Courts ought to be adept at unmasking attempts by a dissatisfied party coming through the back door and under the cloak of having come by new or fresh evidence, seeking to fill in gaps or lapses in his or her case. For the rule is not meant to aid the slothful or the indolent, the careless, negligent or reckless litigant, whether acting pro se or through counsel. The application is not granted on compassionate grounds. Neither is it meant to give the sloven, particularly a litigant acting through counsel and who fails at the trial to marshal his facts carefully or fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigations which would have thrown light on or strengthen his case or give him or her a second chance at rebuilding his or her case. End of quote. This same point was made in the case of Amabe vs. Obus.
Road size of around 80,000 kilometers. That is, if you put together all roads under Ghana Highway Authority, under feeder roads, under urban roads.
And that which denies or grants permission to leave further evidence after the close of the case for the parties. In all the examples cited, the defendant did testify, and the plaintiff found the need to call for fresh or further evidence to buttress their case, though the courts, in almost all the instances, refused the applications. In the instant case, however, the respondent decided not to testify at all, so no situation arises for there to be the need for the petitioner to call further or fresh evidence to clarify anything, be it a doubt or a point raised in the testimony of the respondents, since there was none. The petitioner in his submissions made reference to Section 26 of the Evidence Act 1972 NRCD 75 NRCD 323, which he says operates as a stopper against the first respondent for failing or refusing to call a witness as contemplated by the filing of a witness statement. This section provides, quote, except as otherwise provided by law, including the rule of equity, when a party has, by that party's own statement, act or omission, intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon that belief, the truth of the thing shall be conclusively presumed against that party or the successors in interest of that party in proceedings between A, that party or the successors in interest of that party, and B, the relying person or successors in interest of that person. End of quote. We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38 with 3E5, Sub 5. The rules permit a party to call or not to call a witness who has filed a witness statement to testify, as the mere filing of a witness statement does not constitute an election to testify, as we rightly held in our ruling on the 11th of February 2021. Again, the petitioner did not decide to close his case after the testimony of his third witness just because the chairperson of the first respondent had filed a witness statement. This is because in law, a plaintiff or petitioner does not require evidence from his or her adversary in an adversarial system as ours to prove his or her case. The authorities are alleging that a plaintiff or petitioner succeeds on the strength of his or her own case, but not on the weakness of his or her adversary's case. Conclusion, we wish to reiterate that by settled practice and in the absence of express rules to that effect, a trial judge, just like this court, in this trial petition, has a wide discretion to reopen proceedings before a judgment is rendered. That discretion, however, one which should be exercised sparingly and with restraint, as motions to reopen necessarily involve a balancing of the accountability of counsel for decisions regarding the prosecution of his case and the interests of justice. Accordingly, in weighing the propriety of reopening proceedings to permit no additional evidence to be led or tendered, the court would typically consider the following broad questions. Would the evidence, if it had been presented during the trial, have had any influence on the result? 2. Could the evidence have been obtained before or during trial by the exercise of reasonable diligence? The court will also assess the relevance, necessity, and materiality of the proposed evidence, the effect, if any, the reopening may have on the expeditious conduct of the trial at large, and the importance of the integrity of the trial process, and finally, whether the other party will be prejudiced if the reopening is allowed or a miscarriage of justice perpetrated if it is not. As we've already indicated in this ruling supra, the petitioner in this application has not given us an inkling of the new or fresh evidence he wants to bring to the fore through the chairperson of the first respondent, and how that evidence could assist the court to do justice in the matters under consideration in this petition. Neither has he disclosed how that evidence will advance the course of his petition. For the above stated reasons, we find no merit whatsoever in the petitioner's application to reopen his case for the sole purpose of compelling his adversary's intended witness to testify through a subpoena without indicating the sort of evidence he intends to solicit from the said witness and how that evidence is going to help the court in resolving the dispute before us. We accordingly refuse the application and proceed without any hesitation to dismiss him.
As the court pleases. We are grateful to the court.
My lords, we are most grateful.
My lord, we have listened to your ruling and we will obtain a copy of it. I have to say, my lord, that we are struck by the fact that Section 72 of the Evidence Decree, or the Evidence Act, is not referred to, but Black's Law Dictionary is referred to. But in any case, my lords, I wish to notify your lordship that we have filed this morning, just this in the last half hour. So we have filed an application for review of your ruling of 11th February. And in connection with that, we are also filing an application for stay of proceedings pending the hearing of that review application. And no doubt the next steps in this case will be dependent on those applications.
Yeah, Councillor, excuse me. Please, has the registrar given you any date for the hearing of that application?
Not as far as I know. I believe
it is being filed.
It is being filed. I believe so, because this was about 20 minutes ago, and I don't think that the date has been given yet.
Okay. So we already indicated that this case has been adjourned to Thursday, so you will come on Thursday. Yes. If the motion is fixed for tomorrow, then we can come and take the motion. Yes. If it is for Thursday, you will come and take the Thursday. But our orders still stand. So the court stands adjourned to Thursday. Please.
Order in court, please. Order. Order in court, please. Order in court, please.
I can hear you.
Okay, all right.
All rise.
with regards to roads in Western region and the Western North region.
Sorry, Honorable Minister, did you get the question? I didn't get it. I didn't get the question.
Yes, Mr. Chairman. Mr. Chairman, with the highest respect, I got the question.
Very well. Let me answer.
Yes, we all know, even from our elementary school geography studies, we know that Western region, has the highest rainfall pattern in our country. So it's true that a number of contractors find it difficult to work on road projects in that part of our country. But we are making effort to deal with that problem. But road construction itself requires a lot of water in some quantities, because even if you construct roads during the dry season, from time to time, in order to get good compaction, you still have to sprinkle water. That is why you see a lot of road tankers, water tankers during road construction, because it's a requirement in construction. Apart from the fact that, if the road runs through a town, it's also important to water it from time to time to retire dust. But it's the excessive rainfall that disturbs road construction. So for the time being, since nobody can do anything about nature, the strategy that has been adopted in my ministry and by government is that we are specifically targeting the Western region. And the honorable member, you are aware, because it happened in your own constituency, that instead of giving large contracts, which at times is normally the case, we try to share road jobs. We break them into what we call lots, so that if it's a 20-kilometer road, instead of giving it to one contractor, and there are contractors in this country that have capacity to do 20, 30, 40 kilometers of road at a time. But if it's in the Western region, you realize that we break that length into about 5 kilometers. And instead of one contractor doing 20 kilometers, we give it to about 4 contractors, so that they will be able to work faster on the roads there within the period that the region experiences dry season. And we are going to intensify that, to ensure that we do a lot of roads in the region, because of the heavy rainfall pattern there. Thank you, Mr. Chairman.
Yeah, Honorable, please. We agreed on one, but you were senior, so we allowed you to. Yes. All right. Yes, Honorable Sosi.
Thank you very much, Mr. Chairman. Honorable Road Minister, somewhere in February 2018, you had a tour of Medina Municipality where you announced that some 74,000 kilometers of road were to be constructed. That is in 2018, in February. I want to ask how many kilometers of roads were constructed between that time and the time you ended your office,